The honourable member for Fadden in continuation.
Thank you, Mr Deputy Speaker. I arrive in continuance to lend some comment on the Migration Amendment Complementary Protection Bill. I started my discussion in the House of Representatives pointing out that this is one more iterative change to the policy of protecting our borders, one more in a long litany of disastrous changes that began in 2008. I made the point yesterday that in 2008 there were only a handful, or prior to the last election in 2007, there were a handful of people in detention. And whilst a handful is generally a euphemism for a small number, I mean a handful. There were 4, and I think 1 child. The boats coming to Australia in many years had reduced to 0. At the most, they were 3 per annum. Enter stage left the Rudd government and administration. And in August 2008, the very effective policies that had stemmed a tide of those coming by boat to Australia had been stopped unilaterally. In August 2008, that was pulled apart. We now have had, since 2008, 11,246 people arrive on 224 boats. The government is desperately trying to seek solutions and has put together piecemeal approaches to try and stem it. They unilaterally dismissed offshore detention on Manus and Nauru Island with all sorts of hyperbole of how immoral such a thing was and how inhumane, and now, of course, the Prime Minister is in discussions with Manus Island on PNG and Papua New Guinea. Sheer hypocrisy. They dismissed temporary protection visas that, in concert with the Pacific Solution, had worked so effectively, using the same sort of inflated language, and now the Minister is looking at temporary protection visas for those who had committed some degree of crime whilst in detention. And the Migration Amendment Complementary Protection Bill is another piecemeal approach. Can I make the statement very clear? Either adopt the Coalition's policy sets that have stopped the boats in the past, and I guarantee will stop them again, but don't simply cherry-pick the bits that you think are politically saleable in this damaging affair that is the boat people affair for you, because it's simply not working. The total number of people that have arrived since the last polling day, 69 boats, 3,897 people have arrived. And the total number of arrivals since the current Prime Minister, Prime Minister Gillard, on the 24th of June 2010, 83 boats and 4,694 people. The government has completely, utterly, totally failed to protect our borders. They have weakened our national security to the point where those 3 asylum seekers who were charged over setting fire to the boat that cost a number of lives, they were found guilty, given cursory sentences, and then provided visas to live permanently in Australia. If that doesn't put up a sign that says, "Welcome, come along," I don't know what does. We know if you're in Afghanistan and you're seeking asylum from Afghanistan, you have about a 10% chance of making it to Australia. If you come across into Malaysia, where the persecution you're fleeing has gone and you're free, when you then fly to Kuala Lumpur, where the persecution you're fleeing from is now stopped and you're free, when you come to Indonesia, where again you're free, and then you jump on a boat to come to Australia seeking a better freedom, if you're an Afghani seeking asylum and you take this process, you have over a 90% chance of being given a permanent visa in Australia using the current appeals process. Iterative, piecemeal change is a disaster and doesn't work. So here the government is with another amendment, another piecemeal change to allow all claims for onshore protection to be considered under a statutory process, another process for a single visa applicant against our non-refoulement obligations, in the same way that our non-refoulement obligations are triggered under the Refugee Convention. This bill is remarkably and substantially similar to a bill in the same name introduced in 2009 by the government that the government let lapse. The difference between that bill and this are minor and technical and don't alter ostensibly the function of the bill. Now, in terms of definition, complementary protection is a term that describes a state, Australia's obligation to people, whilst they do not meet the 1951 Refugee Convention definition, nevertheless are in need of protection on the basis that they may face serious violations of their rights if sent back to a country of origin. These amendments insert a statutory process to deal with applications, rather than have the Minister consider applications against our international non-refoulement obligations when asked to intervene or exercise his interventionary powers. The Minister's interventionary powers will remain, however, but clearly they are unlikely to be called upon in this area if a proposed statutory process is put in place. Consistent with ministerial decision powers more broadly under the Act, the Minister's decision, of course, is not appealable. The use of a ministerial decision process ensures broad flexibility in considering the specifics of each case. Now, looking at the facts, between 1 January 2010 and the 20th of October last year, the Minister finalised 1,690 requests for intervention. Of these, the Minister granted visas to 438 people. According to the Minister's office, of those 438 visas, only 6 satisfied the requirement of the proposed new complementary protection provisions. So we're putting in a whole new process, another piecemeal approach to dealing with protection of our borders, ostensibly looking at the Minister's own numbers for 6 people per annum, when the Minister's own ministerial prerogative and interventionary powers allows him to deal with it. 6. A whole new process for 6 per annum. Now, surely the Minister is not that busy that he can't look at 6 cases per annum. Surely he doesn't need another process to deal with just 6. Now, consistent with the evidence previously provided to the Senate Committee, DIAC and the Minister's Office has reconfirmed that they do not expect the number of applicants being granted protection visas under the complementary protection provisions to increase at all. So DIAC and the Minister's Office have indeed confirmed that that number, less than 10 per annum, is about right. So it just begs the question as to why the government believes it's necessary to introduce a statutory framework to deal with less than 10 cases per annum, having just decided in 2009 to let the bill lapse. Why bother? Why bring it back 2 years later when it's 10 cases? It would take the Minister a short amount of time. I'm sure DIAC is suitably professional to provide the Minister with the advice he needs to make decisions. Why do it? Now, in evidence to the Senate Committee, DIAC advised that of the 606 visas granted by the Minister using Section 417 powers in 0809, only 55 were granted out of the humanitarian program, and less than half of these cases involved non-refoulement issues. The Minister's Office has confirmed that no one who would be considered under the new provisions have previously failed to obtain a protection outcome under the current arrangements. They've also confirmed the number of genuine applicants in this category is very small. I think the evidence is absolutely and utterly overwhelming that these measures will not add a single level of protection for those whose circumstances do not meet Refugee Convention criteria, but who may trigger our non-refoulement obligations under other treaties and protocols. The government concedes that our current arrangements have honoured all treaty obligations in such cases. We consider that the ministerial intervention currently in place delivers the flexible arrangements for individuals and families whose circumstances are invariably one-off, that are unique and complex, and who may be disadvantaged by codified criteria administered by officials. The Minister is also responsible and he is accountable for decisions that he makes. It should be noted that superseding ministerial intervention powers with these amendments for another process could also create a surge of vexatious claimants who are encouraged to believe that the government has further unravelled strong immigration control measures. Under this proposal, vexation claimants would be able to extend their stay by appealing the negative decision in the courts. So not only are we dealing with a Minister who apparently doesn't want to exercise his intervention powers for less than 10 cases per annum, we're putting in place a process that will allow vexatious claimants to appeal to the courts to extend their stays. To say this is simply outrageous does not even come close to where we are. There are no additional protection outcomes in this bill. None. It does not provide additional protection outcomes that are currently afforded in practice or in process as we speak. This bill will not lead to any greater protection and/or compliance with existing treaty obligations. There is no suggestion that Australia has been in breach of any of these obligations. There is no suggestion that the government has been in breach of any of these obligations. It therefore begs the question once more. We are not contravening obligations. We're looking at a very small number of cases, maybe 6 to 10 per annum, that are complex by very nature of who they are. The minister has intervention powers under the Act that allows him to make decisions that are non-appealable, but the government wants to throw that out and put in place a bureaucratic process that is appealable to the courts, and the government thinks this is a deterrent to people smugglers plying their vicious and horrid trail. Can I simply say to the government, this bill cannot be supported. It adds no level of protection. If anything, it further weakens it. Can I plead to the government to heed common sense? The government has flip-flopped everywhere, from changing our strong regime in 2008 to then deferring the review of decisions for Afghan and asylum seekers for 6 months and Sri Lankans for other time periods, for a never-never solution of East Timor, to discussions now with Manus, to a 1-for-5 swap with Malaysia. We give 1, but 5 come and we pay for it all, putting aside that when people arrive in Australia, there may well be provisions for them to appeal to the courts to extend a stay and not go to Malaysia, all things that perhaps haven't been considered. Considering the debacle that is the government's border protection regime, can I plead to them to exercise some common sense? History is always a great lesson, and the history shows that the Howard measures worked. They were an effective deterrent. They took away the product from these dreadful people called people smugglers, and people didn't put their lives in their hands when they took a leaky boat to Australia. It had integrity in our refugee process for people coming offshore into our country. It protected our borders, and importantly, lives weren't lost, all of which cannot be said for the government's botched approach to border protection.